Chairwoman, good afternoon to fellow Geauga Countyans and any visitors from outside the county. I'm Probate Juvenile Court Judge Tim Grendell. Today I'm going to wear two hats. I'm going to start off with the probate court hat and then switch to the juvenile. For the probate, I want to bring back to the board's attention House Bill 8. And I sent the board a letter on May 8th of 2015 about this bill. Last year, the prior board attempted to address one of the board members' concerns that the park had acquired property that had oil and gas wells already on it, and that their purpose clause in the bylaws didn't necessarily address the ongoing existence of those wells. And the board amended the bylaws and unfortunately put some language in that was overly broad, giving rise to concerns that there could be oil and gas drilling in our parks. While that threat was not to the level it was exaggerated to, there was the possibility that should the park board vote to enter into an oil and gas lease under that language, that was a distinct outward possibility. I am pleased that the park board amended that language to clarify that there was no ongoing threat of drilling oil and gas wells in the park, because I'm an adamant fan against drilling oil and gas wells not only in our park, but when I was in the state legislature, I voted against allowing that drilling in our state parks. But where that threat was at best theoretical and exploited by some, there was a real threat that would allow oil and gas drilling under our parks in the not-too-distant future. And that is House Bill 8. House Bill 8, by its own definition, is a priority bill, because my 11 years in the legislature taught me something. The first 10 bills in the House are what I call priority bills. Their caucus sits down and arranges those bills for a reason. And that reason is to achieve certain policy goals that the House has. The fact that this bill even has the number 8 on it is a concern of its level of priority, despite what anybody might have said. More importantly, House Bill 8 has already passed the Ohio House by a vote of 98-0 back on March 18th of this year, and is currently pending in the Ohio Senate. The issue, quite frankly, is the language in House Bill 8 that requires the chief of the Oil and Gas Division of the Department of Natural Resources to issue an order for unit operation of a pool or part of a pool that encompasses a unit area consisting in whole or in part of oil or natural gas resources owned or controlled by the state, and here's the big words, or a political subdivision. Current law actually allows another governmental body to authorize oil and gas drilling involving as a unit state property. But the language or a political subdivision that's added in House Bill 8 is a nightmare for local communities. What does this mean? Well, what this means is simply how you drill for oil and gas in Ohio. For example, if you're doing a Utica shale well, which is the new in-rate thing, you need 200 to 400 acres for your unit. That doesn't mean you're drilling wells on the 200 or 400 acres. It means you need 200 acres of subterranean oil and gas rights for one well. Now, what does this bill do? This bill says that if I own the land next to this park, or I have an oil and gas lease to drill on the land next to this park, today, if I wanted to include this park in that unit for that well, I would have to enter into an oil and gas lease approved by this board. Hopefully that won't happen. The board will not approve it. But under House Bill 8, the board is meaningless. Under House Bill 8, the entire acreage of this park becomes part of an oil and gas unit for a well on property next to this park, simply if the person who applies for the unit permit asks the Department of Natural Resources Director to include this acreage in that well unit. And in fact, if House Bill 8 goes into law, the park board will have no legal authority to stop the inclusion of park property into the unit for that well. To tell you how bad this is part of what's called mandatory pooling. It dates back in Ohio to the 1970s during the oil embargo and crisis. Back in those days, the legislature passed for private property something called the mandatory pooling law. And what that says, for example, is if you needed 20 acres for a lower surface well, not a shale well, but a lower surface well, and you had 16 acres under lease, but John Karlovic had the last 4 acres, and he didn't want to sign a lease to give you his 4 acres as part of the unit for that well, then a private citizen holding those 16 acres could apply to the director of the Department of Natural Resources Mining Division for an order directing Mr. Karlovic to include his 4 acres in the 20 acres for our well. Under that law, which has been on the books for 40 years, Mr. Karlovic could protest. Mr. Karlovic would be entitled to a hearing, and if Mr. Karlovic didn't like the discretionary decision of the Director of Mining to say his 4 acres goes into the unit, he could appeal that decision to a special board. Unfortunately, most of that board is made up by people who have an interest in the oil and gas business, and so that decision, unfortunately, was probably not going to come out the way Mr. Karlovic wanted. But at least he got due process, or some semblance of it. Under House Bill 8, none of that exists. Under House Bill 8, if you own an oil and gas lease next to a public property, whether it's a county park, the town square, Kent State Geauga campus, a local township park, a fire station, any of those, if you apply for a permit that includes the subterranean rights, under the ground mineral rights of that public property, the Director of Natural Resources has no discretion under House Bill 8. It says that he shall include that public property into the unit for the oil and gas drilling. In fact, if you ask the Director of the Department of Mining and Natural Resources, he'll tell you he doesn't like House Bill 8 because it took away his discretion when it came to mandatory pooling. Now, you've got to ask yourself a question. We're sitting here on October 13th, 2015, and a bill that was the largest taking of public property rights in the history of the state of Ohio passed the Ohio House by a vote of 98-0 7 months ago. There was not a single negative vote. If you folks were worried about oil and gas drilling involving our parks last year, you should be terrified about House Bill 8 because it does 2 things. It directs that the public property be included in the unit, and it takes away the authority of the board to do anything about it. I came upon this problem in May, not because I was reading legislation, but because I was contacted by some friends of the Cuyahoga County parks who were greatly concerned that this bill would allow oil and gas drilling under the Cuyahoga County parks. They are led by a group of people from Gates Mills. They have put together an organization, and they have attempted to lobby this bill in a different direction. But if this bill passes the Ohio Senate and is signed by the governor, oil and gas drilling under our parks will be a given someday, and nobody on the local level, including the board, will be able to stop it. I talked to Senator Eklund. Senator Eklund said he was preparing an amendment to exclude county parks from the bill. That would be a good start. But don't forget, it's not just the county parks. It's all property owned by a political subdivision. That's townships, villages, cities, school districts, universities. It's all public property that they would be able to drill on. Now, how do you drill on this property? Well, it's called horizontal drilling. You come down on the private property and you drive the well under the public property. In this case, our parks. And you pull the mineral rights out of those parks. The park district gets a royalty. It's a 1/8 overriding interest. But what if those pipes cause environmental damage? The average drilling company is not overly bonded or overly financially well off. And it will be the park that bears the burden of any environmental negative effects of horizontal drilling under the park property, or under Kent State Geauga, or under the Chester Town Hall. And that's why this taking of the subterranean rights without any local control is a potential nightmare. Now, by the way, the legislature not being stupid, they did exempt one state-owned property from this bill. All state parks in existence prior to January 1st of 2015. So the only public property in the state, should this bill pass, that will not have horizontal drilling under it will be state parks. But there'll be nothing this board this community can do to stop the drilling should this bill pass in the Senate. The bill will have more hearings in the Senate. There's hope that we can at least exempt parts from the bills, although I'm not sure how much of a given that is. But if you're really concerned about oil and gas drilling on your parks, and I asked the board again in my letter May 8th that you contact your counterparts in Cuyahoga County and join with the state organizations to try to get House Bill 8 either blocked or at least seriously amended to take away the provisions that affect our parks and take away your authority to decide what's going to happen underneath our parks. This was a clever move by somebody in the oil and gas industry to figure out how to have hundreds and thousands of acres included in their units without having to negotiate leases. And it's going to be great unfortunate should this measure go into law. From talking to the folks in the legislature and some folks from the Cuyahoga County unit, they are planning on going down and testifying when the hearings are started in the Senate. You can contact Senator Eklund. He is aware of the situation. My last discussion with him is he's looking at an amendment to at least exempt parks from the process. But if you're really concerned about oil and gas drilling in the parks and not about just saying and complaining about it, you need to do something about House Bill 8, and I ask the board to take some action in that direction. So I thank the board for that opportunity. And now I'd like to switch and put on my juvenile court hat for a minute. And I'd like to start with talking about the Liberty Camp, which is a nationally recognized educational program that helps educate our children about our founding principles, our founding fathers, and about the liberty and freedoms on which this country is based.
We need to turn off the light. Good morning.
For freedom of speech, we must die.
The goal of Liberty Camps is to bring the founding days of America's history to life for the children who will be the future of America in years to come. Talking to Dr. Ben Franklin.
That's the democracy.
Listening to Patrick Henry.
We're free to do what is right.
Experiencing what the passion of the Minuteman in battle. What they teach in school is events with dates that you have to memorize so that you pass the test. That does not build a heartfelt love for this country. You do not become a patriot that way. They go from station to station, always still in the 1700s, not 21st century, computerized children. They actually get their own Declaration of Independence, and then they sign their Declaration of Independence with a true turkey feather.
They became a part of all of the reenactment, and I think that says a strong recipe of freedom. To protect themselves and fight for what? For freedom.
I really hope that we can impress upon these children. This land is a free land. Not by accident, but by purpose and by plan. And that it should be free forever like this as a light for the rest of the world where people can come and grow and prosper and experience the benefits of liberty.
As Geauga County Juvenile Judge, I am statutorily responsible for the care, protection, and mental and physical development of our youth in Geauga County. Liberty Camp is a shining example of what positive volunteers in this county can do to help educate and prepare our children for the future. I find it interesting that the first thing you saw in that tape of this nationally recognized program was the discussion that freedom of speech, and freedom of speech is the First Amendment and one worth dying for. Freedom of speech was not earned by a petition or by a letter to the editor, although Pastor Sanders is here today. It was earned in part from the speech of the pulpits of those brave pastors who put everything at risk back at the time of our revolution. But the truth is our freedoms and our liberty was earned at the end of a musket, at the end of a cannon. It was earned by gentlemen who died carrying those muskets, fighting for those fundamental principles that we exercise in this room here today. And I can only take this time to ask Linda O'Brien and our Liberty Camp people to come up and John Oros to come up, because I think it's fitting, as the juvenile court judge required to maintain the responsibility for care, protection, and mental development of our youth that we take a moment to recognize the Liberty Camp for its contribution to the children of our county this past summer. For truly, Liberty Camp helped protect, conserve, and protect the history and principles of our founding fathers that through their sacrifice provided the fundamental liberty and freedom that we all enjoy today. And by continuing to educate our youth, Liberty Camp, working with our park district, using those wonderful resources, will help protect, conserve, and protect those fundamental principles of liberty and freedom for future generations. And I think it's fitting that our park district does more than just teach people about butterflies and streams. It educates the whole person. We have an observatory that looks to the stars. It doesn't preserve the stars. It doesn't conserve the stars. You could argue it might help protect the stars because we understand them. But it's there to educate. Because when you educate the citizens of this county, you preserve, conserve, and protect something even more important, and that's knowledge. And knowledge that's passed on from generation to generation is what's made this country the great country that it is. And it's the failure to pass that knowledge forward that will condemn this country to the history that all other great civilizations have succumbed to. We have at Westwood's programs that show you the formation of the earth and show you the Ice Age. Now, they're not preserving the Ice Age, folks. Those are gone about 10,000 years. But they educated people as to what the Ice Age meant and how the earth was formed so that they have a better understanding of the history from which we come and to where we're going. And that's what Liberty Camp did. And for anybody to sit here and say that it's wrong for our youth to sign the Declaration of Independence, I think everybody in school should have to sign the Declaration of Independence and understand what this country is built on. To say that it's wrong to honor the Minutemen who died carrying those muskets, this is a disservice to the youth of our county. And I'm proud to stand here today and ask Mr. Rohrs if he would join me and Ms. Shumway would join me as we recognize, first of all, the County Park District for its using our resources to help educate our children about the founding principles on which this country is still formed. On behalf of the Geauga County Probate Juvenile Court, I would like to commend the Geauga Park District's support of Liberty Camp Geauga. As juvenile court judge, I am responsible for providing for the care, protection, and mental and physical development of the youth of Geauga County. The education of fundamental rights and liberties that Liberty Camp Geauga provided in an active outdoor environment contributes to the mental and physical development of the youth of Geauga County and is an investment in the individual lives of our children. Beyond that, educating our youth in the history of our country promotes an appreciation for the very constitutional principles that the Founding Fathers fought so hard to create, which are necessary to preserve, conserve, and protect the freedoms that are only available in the United States. I thank the Park District, the board, Mr. Rohrs, and your great staff for this contribution to the youth of our community. Mr. Rohrs is here. I also want to give him his own particular commendation because he was one of those Minutemen who helped represent the sacrifice of those who came before. John, thank you very much. Commissioner Claypool, I saw you here somewhere. You want to come on up for a minute, please? Linda O'Brien, Commissioner Claypool, and about a dozen other people used their time positively and wisely for the youth of our county, contributing to the benefit of not only their knowledge of history, but hopefully carrying their history forward. So on behalf of the Geauga County Probate Juvenile Court, I would like to commend you, Linda O'Brien, for your hard work and dedication to the development and successful execution of Liberty Camp Geauga. As juvenile court judge, I am responsible for providing for the care, protection, and mental and physical development of the youth of Geauga County. The education of fundamental rights and liberties that Liberty Camp Geauga provided in an active outdoor environment contributes to the mental and physical development of the youth of Geauga County and is an investment in the individual lives of our children. Beyond that, educating our youth in the history of our country promotes an appreciation for the very constitutional principles that the Founding Fathers fought so hard to create. When children appreciate their history, they're less likely to risk their future. Linda, thank you so very much for your contribution to our children of our county. And Commissioner Claypool, also to you, as one of those active players. I believe you were Thomas Jefferson, right? I was. And you did him justice. Congratulations for your contribution. I appreciate it.
that it took a team of almost 25 adults for these 56 children that we had. And so that was a 2-to-1 ratio. And they were dedicated, they were empowered, and they loved what they did, and they contributed greatly. And I am forever appreciative for all their efforts and all their contributions. The kids loved it, to say the least. And they still talk about it today. I think they'll still be talking about it next year. But these adults gave of themselves to make that happen, and I thank you.
Would you mind making? Linda is too humble to make this comment, and so I will make this for her. Some of us played a minor role in that event, and it was truly astounding to watch the kids' faces as they looked up at us as we were talking about the founding of this country. I had one 6-year-old who I asked a question, do you know what the founding documents were? And he went on and on and on, and he amazed me with his knowledge. But I'd like to ask Denver Sally and some of the others in this room who are participating in that to stand up and to recognize Linda, who worked her heart out on this event for our kids. She worked tirelessly for hours and hours and hours with a group of volunteers to help her. There's an event coming up this Sunday in which Linda is also leading. It's all about America and patriotism and our veterans. And I applaud this citizen of our county. It's because of people like this that we have such a great county to live in. And I give her a lot of kudos for her courage in doing this, because sometimes that requires a little courage, being a little different, stepping out. And I want to thank her and everybody else that helped.